who's experiencing gender-based violence. They'll have a video suite. It'll be in a surrounding, a setting that, again, puts them at ease. Nothing like a formal interview room. And every sort of possible requirement or condition to make that experience easier, it is implemented. Contrast that with what you have in the context of an individual reporting that they've experienced gender-based violence to immigration authorities, how they're treated, how they're interviewed. There isn't that parity, and I think that that's something that certainly strikes me, that yet they are both organs of the state, but there is a different approach, a perhaps less sensitive approach, I would say, to refugee women compared with those who are born and settled in the UK. I'm conscious of the time, so I'm going to move on briefly to look at legal developments and some jurisprudence. I ought to say that just touching on the approach in the UK, where there are gender-based violence claims, the approach that is taken by legal professionals is usually to seek to argue that a woman and girl, and I'm going to restrict it to that definition just for now, has suffered or is at risk of suffering a particular form of gender-based violence if returned to their country of origin or the country that they're fleeing, and would be protected, or it would be argued that they'd be protected under the Refugee Convention on the grounds that they fall within a particular social group, and possibly political opinion, possibly on the grounds of religion, because they're transgressing religious norms, such as in the case of FGM, refusing to participate or undertake that procedure. That is one of the mechanisms by which victims of gender-based violence obtain protection. The other is, and a case that's useful, but I'm conscious of the time, a case that's useful for your reference is a House of Lords authority from 1999, the case of Shah ex parte Islam. That was just very briefly two Pakistani women who were forced to leave abusive husbands. They were at risk of being falsely accused of adultery, and it was determined that they formed a particular social group, given that they were women in Pakistan. That formed a particular social group as a consequence of the fact that they lived in a society which discriminated against them on the grounds of gender, and given their experiences, they wouldn't be afforded the protection that they would need to protect them from the risk emanating from the accusations of adultery. So that's a useful House of Lords case from the UK to consider when looking at women who've suffered gender-based violence forming a particular social group and attracting protection under the Refugee Convention. But interestingly, when trying to marry this up with the Convention against torture, what I would say is that the approach in the UK is to rely on Article 3 of the European Convention on Human Rights. Now, Article 3 in some ways mirrors the language of the UN Convention Against Torture, in that no one shall be subjected to torture, inhumane or degrading treatment or punishment. But rather than relying on the Convention Against Torture, it is Article 3 that will feature in a lot of the UK jurisprudence. And in order for there to be a finding that there has been a breach of Article 3, there is no requirement for there to be a finding that the physical mistreatment has been inflicted by or on the instigation of a public authority or person acting in their official capacity, and nor is it necessary for there to be a specific finding of torture in order for there to be protection afforded under under Article 3. I want to try and move swiftly on to some of the cases that are useful and that might assist when comparing different jurisdictions on this issue of cases concerning gender-based violence. Firstly, looking at rape and sexual violence, there is the case of Ayadin and Turkey, that's a 1998 authority. The reference is in 1998 EHRR 251, and in particular, if you do have a copy of that case or want to obtain a copy, I draw your attention to paragraphs 80 to 87. The background to that case is essentially that a 17-year-old girl had been detained and questioned about her political activities and specifically her involvement with the Workers' Party of Kurdistan. She'd been arrested by security forces, and during that period she was held, detained, and not only questioned, but she was also subjected to being stripped, put in a car tyre, cold water, jets of cold water being poured over her, sprayed onto her, and also raped. And it was held that the accumulation of those acts of physical and mental violence, especially rape, given the particular circumstances, and being carried out by a state official, clearly, in the court's view, amounted to torture and was also a breach of Article 3, the article that I've already referred to, that is part of the European Convention on Human Rights. More recent cases from a UK perspective that, again, are useful and worth considering. One is A and the Secretary of State for the Home Department, that's a 2003 authority. The reference is EWCA Civ 175. This concerned a Jamaican national. She'd lived in an area dominated by gangs, and a particular gang had shot her daughter, her son, and she was forced to move and relocate, but unfortunately she wasn't welcome in the areas where she was relocating, and she had suffered sexual abuse. The gang-related activities and the sexual abuse that she had suffered, again, it was held, engaged Article 3, that she had suffered inhumane and degrading treatment. There wasn't, and it isn't necessary for there to be, as I say, a specific finding on torture, but nevertheless, that experience of gender-based violence attracted the protection to for that individual. Another case that I'd again draw your attention to is a House of Lords case of Hoxha 2005. Now, in that case, there was the background is that the claimant, Kosovan Albanian, had suffered gross ill treatment by Serbian forces. And although this wasn't a central feature of the case, within that particular authority, Baroness Hale, who's now the President of the Supreme Court in the UK, explored the specific issue of one of the claimant's wives and her treatment by Serbian forces that wasn't explored or argued before the House of Lords or indeed the appellate court below, so the Court of Appeal, but nevertheless is, I think, an important decision to look at, to just consider some of the guidance or the approach that should be taken when looking at sexual violence. And in particular, Baroness Hale was clear that while women may be viewed as propagating the ethnic or racial identity and persecuted in a different way, such as through sexual violence or control of reproduction, if sexual violence is used in this way, the consequences not only for the woman herself, but also for her family, may be long-lasting and profound. This is particularly so if she comes from a community which adds to the earlier suffering she has endured, the pain, hardship, and indignity of rejection and ostracism from her own people. There are many cultures in which a woman suffers almost as much from the attitudes of those around her to the degradation she has suffered as she did from the original assault. I think, again, it's worth reading that judgment because of the analysis that's given in terms of the proper approach and the recognition of gender-based violence and sexual violence in particular in those circumstances. The final authority under the category of rape and sexual violence that I want to touch on is the case of PS Sri Lanka against Secretary of State for the Home Department. That was 2008 authority. The reference, if anybody wants it, is EWCA Civ 1213. This concerned a 26-year-old woman who was Tamil and had repeatedly been raped on different occasions by Sri Lankan soldiers. On the last occasion, her father was forced to watch this horrific sexual assault, and she attempted to commit suicide. She poured paraffin on herself. Her father intervened and assisted in her fleeing the country. And again, Article 3, the article that relates to torture, inhumane, degrading treatment or punishment, was said to be engaged because there was a real risk that she would be targeted for rape by soldiers in Sri Lanka were she to be returned. I'm going to bypass perhaps some of the cases that relate to FGM, but if anybody in the lunch break wants to talk to me about them, then I can certainly go through those. Are there any particular legal developments or cases or principles that people want to share here that might assist in this symposium? I know that there are some Hong Kong cases that we'll come on to, which are a stark contrast to some of the UK-based and European cases that I've referred to, but we can have a discussion certainly about that. In terms of moving forward and thinking about guidelines, suggestions for improvements for working specifically with those victims of sexual gender-based violence, clearly we have certain developments and legal developments or jurisprudence from other jurisdictions that assist. And Juliet's talked about the approach that should be taken, I think, when dealing with disclosures of this nature. You mentioned earlier in your introduction about the advice that you've given or contributing to the guidance for, I think, immigration authorities. Was that on a European basis or?
Yeah, so this is from the European Asylum Support Office that provides training to all member states on correct decision-making for the asylum procedure, and they have core modules and specialist modules. So the core modules are interview techniques, evidence assessment, and the legal principles, and one of the add-ons is interviewing vulnerable persons. They also have a specialist one on trafficking human beings and a specialist one which we call gender and SOGI, which is gender, sexual orientation, gender identity, gender-based violence, including the honour-based and FGM issues as well. So they have all these really very comprehensive trainings which are for immigration officers. They train the trainers and then they have cascade training in all the member states who will send people to it. Unfortunately, it's not binding on them, and it's also not binding on them to do any kind of audit and evaluation of the training and its application, how effective they think it is. But, you know, EU is spending a lot of money on it. I think they get quite a good take-up across member states. So, on the whole, I think it's a good thing.
So, in preparation for today, just following on from what you've said, I looked at the Home Office's most recent guidance on gender issues in the asylum claim. It's a document that was published in April 2018. This is, of course, a UK-based document, and for those who are interested, I have a copy here if you want to have a look over it. One of the areas it looks at is taking gender into account during the asylum interview and decision process. For example, and these are approaches that I'd suggest could be developed or adopted in other jurisdictions. Requests for a male or female interviewer or interpreter. Again, that might assist in terms of some of the barriers that we've discussed to disclosing incidents or experiences of gender-based violence. Childcare during asylum interviews. Now, I remember when I was doing asylum appeals in the tribunals, and often I would have clients who would attend with their children to a hearing, and there wasn't a particularly sympathetic approach adopted by the tribunal or the judges, and it was evident that they ought not to be sharing some of those experiences of sexual violence or rape, however young the child might be, in the presence of the child. But yet from the judiciary and the tribunal, it was almost seen as a nuisance that why hasn't this person actually managed to obtain childcare when really they should have, rather than a sensitive approach. So it's heartening to see that certainly in the Home Office guidance, as far as the asylum interviews are concerned, there is certainly an acknowledgement that there should be childcare during asylum interviews, for the very reason that I've touched on, that to share or talk about sexual violence or assaults in the presence of a child is not only contrary to the welfare of the child, but also inhibits the complainant, the victim, from expressing themselves fully about their experiences, which is already going to be a difficult situation. The interview process also under the policy and the guidance looks at what conduct and consideration should be taken into account, whether with advance notice an individual should be entitled to bring along with them a friend for support, for emotional support. I have to say I've not come across that. I've come across interviews where a legal professional will be present, but not ones where a friend or relative is entitled to or is permitted to attend to support the person claiming asylum. Another aspect of the best practice, if you will, according to the Home Office in dealing with asylum interviews and decisions, is that during the interview process to recognise the disclosure where there is a disclosure of a sensitive nature, something which is difficult to talk about, such as gender-based violence, that the interviewer has acknowledged and heard what is said. For example, to say, "I'm sorry to hear that." Now, as part of the process in the UK, when an asylum claim is made, there is an interview process and there's a transcript of that interview. Sometimes it can be typed, sometimes it's usually a handwritten as opposed to a recorded verbatim interview record. But I have to say, when I was practicing in this field, I never once, upon reading an individual disclosing that they have been raped or suffered sexual violence, I never once came across an interviewer saying, "I'm sorry to hear that." And although it might be in the guidance, unfortunately, I think perhaps what's happening in practice is different. Nevertheless, I think there's an acknowledgement there that that is best practice. And if that could be incorporated by immigration officials globally when dealing with refugees who've experienced such violence, then that can only be a positive. The guidance also helpfully, I think, looks at credibility and gender issues. And again, this was something that Jane touched on, that when accounts are being provided, there is this assessment of credibility in the absence of any other corroborative evidence that is deemed sufficient by the immigration authorities. And I'd remind ourselves of how important it is to note that immigration officials ought not to take a very bland, sort of unsophisticated approach to how an individual presents when making a disclosure which is particularly sensitive, such as one of sexual violence. And that a woman, it says here, how a woman presents herself physically at interview, for example, whether she maintains eye contact, shifts her posture, or hesitates when speaking, that ought not to be really determinative of her credibility. Demeanour alone is an unreliable guide to credibility, and it's important to remind ourselves of that when looking at decisions or the approach taken by immigration decision makers, because how often do we see this? How often do we see perhaps too much emphasis on how they present and how they convey details, and not being able to express themselves fully because of those internal barriers as well as external barriers, and that being held against them. So again, it's a useful document to look at when considering the UK's approach to dealing with gender-based violence. Finally, I want to just touch on the position in Hong Kong. And I think you've been provided with some case studies about some example cases and how, when looking at sexual gender-based violence, the unfortunate, I have to say, when I've read this, the unfortunate approach taken by the authorities in Hong Kong, it struck me how not only insensitive, but how lacking in understanding those who are making decisions really are. Now, I mentioned a case I mentioned a UK case that dealt with a woman who'd suffered sexual violence in Sri Lanka. And I'd ask you to compare that to perhaps the second to last case study and case extract. Female Sri Lankan, 29th of June 2018. And just read that to yourself, bearing in mind our discussion earlier about how a Sri Lankan victim of gender-based violence was dealt with in the context of a UK case.
I'd just like to add about the non-disclosure thing that there's some Home Office statistics from their own research about UK citizens disclosing sexual violence. And this study found that 89% of victims of serious sexual assault told no one at the time of the assault, and only 38% reported to the police. So that's UK citizens who are literate, able to speak the language, knowledgeable about where they can go for help, supported perhaps by family and friends, and they don't disclose. And all the stuff in the UK about historic sexual violence and child sex abuse only reinforces how many years people will live with these experiences before they disclose to someone, and many clearly never disclose at all.
Which I think comes back to the point about how there is this double standard almost, despite the guidance.
Yeah.
It's suspended when dealing with refugee women. So I don't know if everybody's had an opportunity to look at that case study. That's the second to last case study. What struck me, again, was something that Juliette's just touched on. When assessing the credibility, the criticism made of her that after this claimant came to Hong Kong, she didn't tell anybody about her alleged rape, although she sought assistance from the charity Christian Aid when she experienced difficulty with her employment in Hong Kong. When we look at that in the wider context and what we know of those who've experienced sexual abuse or violence, is that a fair and proper approach when assessing her credibility? I would say not. And surprisingly, paragraph 12 of this extract, the reference to, again, her evidence being vague, no acknowledgement of why that might be, and then the reference that shows that the applicant was subjected to forceful sexual intercourse. But then the irrational conclusion, it does not of itself corroborate the applicant's evidence that she was raped. Does anybody else have any views about this? I mean, I was really astounded when I had to read these, and I know that Lisa had already forewarned me that I was going to get a bit of a shock. That's a bit of an understatement. Yeah, any other thoughts that anybody wants to share? Yeah.
So I practice in Pakistan, and my organization, we have a project on gender-based violence, and one of the things that we just completed is a research study which looks at the extremely low conviction rates for rape cases. Now, in the majority of the cases, as everyone is familiar, they're not reported. And even the ones that are reported in Pakistan, they don't go through the full trial. At some point, the victims or the witnesses will resign. There's only a handful of contested acquittals, and even amongst the contested acquittals, the conviction rate is very low versus the rate of acquittal. So we tried to assess where are the gaps in evidence. And you'd be surprised to know that not very surprised to know, I guess, but one of the reasons is the failure of the victim or the family to report in time. That directly affects her credibility. Now, in our case, and we looked at a rural district, in majority of the cases, these women are not the primary, actors that interact with the world outside, including law enforcement agencies or anyone else. They're very insulated in their home environment. So oftentimes for them to be able to build that consensus to report involves a family discussion, where members of the family are not necessarily in support of reporting. So some delay is inevitable in that case. Another common scenario in which rape takes place in Pakistan is abduction. So oftentimes you are abducted, you're taken to a discrete location, you return after several days or even months at times. And then in that context, the failure of the family to report that their daughter is missing adversely affects the victim when she returns. So whatever she says at that particular point, it doesn't matter. And in her defense, she couldn't have said it earlier because she just returned. But the fact that the family did not report affects. However, when we spoke as part of that report to government officials, their assessment is that the majority of the victims that are honest victims, and the ones that actually are victims, don't report. Because, who wants to talk about something that is, a direct attack at their honor? So there's a presumption that the ones that report already are, part of, attacking someone's credibility or part of a larger.
So they're false reports, effectively. That's what they're being accused of.
Yeah. So there's a presumption for that. And it's crazy because, what do you do? There's a presumption that if you're honest, you wouldn't report. But then they're asking you to report to prove your honesty in time. So it's really, we've seen so many situations like that where it seems like, what do you want? To be able to prove that. So this example really corresponds to the majority of the cases that we examined, where the courts held the failure to report on time, or the failure to report the full story at different times, or the failure of the family to all adversely affect the credibility of the victim in a rape case.
It's so disappointing, but it's such a linear approach, isn't it, to just take that into account, either the timing or not sufficiently detailing the account on the first occasion, when the reality is, when we look to other professionals, there are so many other reasons why there is that reluctance to do that. Do you see it changing in Pakistan, or?
So we do have a precedent from the Supreme Court which says that technically, even if no other evidence exists, the sole testimony of the victim is sufficient. But in practice, it doesn't really translate, because they inevitably look for corroboration. Mm-hmm. And they do employ these, ways to assess credibility of that testimony. So, we have had amendments in the law that, for example, now bar, bad character-related questions, in trial. And that's 2016. Mm-hmm. So we're still not at the implementation phase, especially at the trial courts, where most of the rape cases start and finish, because hardly anybody appeals, because legal aid and all is also challenging, and it's a long process. I hope it changes, but I don't see it changing as fast as it needs to change yet, unfortunately.
Anybody else want to share any experiences? Yeah.
I just want to make a comment, and I think right at the start you mentioned the definition of gender-based violence, and you mentioned the private and public aspect of it.
Yeah.
But what we try and grapple with quite a lot is it's often too juxtaposed, the two concept of it either being private or public. And in trying to expand protection, by inserting, looking at the asylum-producing countries as well, what is the state's responsibility and what's their culpability, even when the act is private. And on the asylum state, when we're looking at another state that is wholly ineffective in protecting their own citizens, how do we make that argument and strengthen that argument? A lot of the cases in Hong Kong are refused on the basis that, look, they should have just tried to do what they can within their own state. But what we hear and see over and over again is that's just not possible, given a lot of the comments that we're hearing. So how do we breach that gap? And do you have any suggestions, or have you seen any fruitful arguments that have been made in that context?
It's difficult to, I suppose, in the absence of understanding this jurisdiction and my limited understanding that I've gained just from reading the case studies, but all I can suggest is trying to put forward principles that have been established in other jurisdictions to try and make the argument that certain categories do fall within gender-based violence, but also ill treatment. The difficulty you have here, as I understand it, is that the test is quite high if you're trying to argue torture. And although rape is acknowledged as torture in other jurisdictions, I'm not clear whether it is here, and I don't think it is. Is that right?
They do apply a very high threshold, and they do classify it a lot of time as a private act, even when committed by a public official. They just try to frame it as a private or individual act. So that's kind of the thing that we do struggle with.
I've read that in the cases that they try and distance themselves from saying that this is approved by an authority. There's one case where I think CID officials commit sexual acts of violence on a claimant. And again, all I can say is that certainly from a UK perspective, the argument is, well, there is no protection afforded in that state to this happening, even if it is an individual. But I don't see how properly you can say that if it's a CID official, that this is a private matter. because
But
they are...
used to do that in the UK. You used to see a lot of decisions
That
using
were-
a special phrase. These were the isolated acts of unsupervised individuals, and therefore it doesn't form part of the claim of torture. And then they dropped
Then there's
that.
a
So was there a
change.
test case that
I think there's
took that out?
a change in thinking in terms of how to approach that. But, I mean, sorry, do you want to come in here?
So you mentioned how with UK jurisprudence you have the UN CAT and then you have Article 3.
Yeah, the European
We've
Convention
sort
on
of
Human
had
Rights.
a similar change since 2014 where now we have the Bill of Rights, Article 3, where it's torture and CIDTP, and we don't have the requirement of acquiescence or instigation by an authority. So in that sense, it's...
And so what jurisdiction are you talking about?
Acts now, they'll say, yes, it's not torture under CAT,
Right, okay.
but that's become irrelevant because
Right.
we can rely on Article 3 of the Bill of Rights.
Of the Bill of Rights, right.
Whether or not it's instigated or with the acquiescence of or so forth, tends to now fall under the state protection
Right.
issue. So they then push it under state protection. They say, well, look, because it wasn't instigated by the government as a policy, you can report it to the police. So I've had a case with a Sri Lankan lady. So woman's subjected to spousal rape.
Right.
And under Sri Lankan law, there's no spousal rape recognized unless the partners or the spouses are legally separated.
Right.
And in this case, they weren't legally separated, so there was no legal protection. So in that case, the fact that it was a private act or domestic violence, so-called, for which there was no legal protection, actually meant she was more likely to succeed with a protection claim in Hong Kong than had she been raped by a government official, it not being part of government policy.
Right, okay, I see.
Yeah.
That's quite interesting. Right, I'm conscious of the time. I'm eating into your lunch break. Are there any other comments, observations? As I say, Juliet and I will be around in the lunch break if anybody has any questions or wants to talk further about some of the material that I referred to. Do you know where the lunch is?
Yes, I do know. So lunch is until 1:30. So for the speakers and international delegates, you are required to go down to the second floor where you have a brief debrief. For all the local participants, unfortunately, we do not have lunch provided for the symposium, but we have a slip here. This is really loud. There's a slip here with various places on campus that you can pop off to for lunch. So thank you very much for that useful session. Very thought-provoking as well. Thank you.
Got the rest of the day to do lots of talking, I see. So when are you flying out?
Tomorrow night.
Wow, you weren't tempted to... Hi.
Citations.
Yeah, of course. Yeah, no problem.
Because there were quite a few.
Yeah, there were quite a few, and that's...
Sorry for the trouble.
No, not at all. Do you want me to type them out, or do you want to type them out for my notes?
I'll just
So, they're all the ones in black. So that's in relation to rape and sexual violence, and there were two that I had in respect of FGM, which I didn't cover because of the lack of time. So I'll show you. No, go for it. Are you speaking tomorrow as well?
No, so I think they've sort of crammed me into today.
And you weren't tempted to stay on?
Look, it looks a really interesting programme, but I've already kind of arranged other things. I'm hanging out with a friend tomorrow who's working here, so...
Oh, right, okay.
And then I've got to go straight into an all-day meeting on Monday.
So did you fly from London?
Yeah.
I flew from Manchester, so it wasn't too bad. But usually I try and fly with the Middle Eastern airline. I don't know who you flew with, but this time I flew with Air France, and I was a bit nervous because I always think the Middle Eastern airline's slightly better in terms of just generally their service.
I have found them really good, but no, they booked me on BA just because the timings worked for me. So because I've just got this ridiculous day. On Monday I arrive at 5 a.m. and then I'm speaking at lunchtime at this meeting.
Do you ever do any training up north, which is where I'm based? I'm based in Leeds. So do you ever do any training up there?
That was really interesting.
Oh,
in a terrible way.
Yes.
I just have a quick question. I'm a researcher at CCPL in Lisbon. I'm looking into LGBT asylum claims in Hong Kong. I'm doing research on that. And I was just wondering because, the recognition rate in Hong Kong in general is like less than 1%. So that's like general it's terrible. But then I look into some of the cases specifically for LGBT claimants, and then one of the claims that they put forward that if you're we have to prove that the state is not willing to provide protection for the individuals, right? But then for a gay person, if there's a country that criminalizes homosexuality, even though the criminalization may not have been used or practiced, then that itself is the evidence that the state couldn't protect.
Right.
That, right. So because I read I'm sure you know the HJ case in the UK in 2010 about.
Is that the Iran case?
Yeah, the Iran and the Cameroon case.
Yeah.
That actually, I was just wondering if that could, be used as. I was just wondering if that
So
in
there's also
itself
that.
is already evidence that the state couldn't protections.
The current position in the UK is that it's deemed unduly harsh if you're to conceal your sexuality, if you're required to conceal your sexuality from the country that you're fleeing or where you're being persecuted, which seems to be at odds with the decision-making approach of the jurisprudence here, I think. Mm-hmm. Just from the cases I've read, I don't know if you managed to read the case studies. You're probably more familiar than I am with them.
That one,
yeah.
I'm actually working with. I actually know that person, so I.
Oh right, okay.
Yeah, so I've read that.
Okay. So that's the thing that kind of jumped out at me when I was looking at these case studies. That's the distinction. There's a very different approach in the UK where it is deemed unduly harsh if you're having to conceal your sexuality from the state from which you're fleeing. And I think, in terms of your research, I think it's also useful to look at some of the Home Office guidance specifically on.
Are the cases open to public?
Yeah, I mean, I can show you. I'll show you on my laptop actually. I'll just help this colleague.
I'm just curious, these are the specific paragraphs that we're
Oh yeah, I mean those are the specific paragraphs that I
see.
if we had enough time.
Right.
In fact, look, I can give you the copies if it helps.
Oh, would that be too much of a hassle?
No, don't worry. I can print these off, and actually, it'll save me some time. It'll save me some space in my suitcase. So why don't you just take those?
Cheers. Thanks a lot. Yeah.
Let me have a look.
Thank you for being so informative.
No, you're welcome. And there are some more if you want some more. This is the FGM cases that I didn't manage
sure,
to.
that might help as well.
I didn't manage to touch on.
Cheers. Thank you.
Okay. So there's one.
That sounds.
I'll come down in 2 ticks, but why don't you go ahead?
Okay.
I'm sorry about that.
No, it's all right. No, it's all right. I'm just going to see if I can first of all, connect to the internet. That would be helpful.
Do you want to connect to the exchange?
Yeah. Do you know?
Yeah.
Great.
So have you worked on like specific LGBT asylum?
I haven't. The Cameroon case was actually a colleague of mine who's came over in my chambers, but
Right.
yeah, he worked on that.
Okay.
So
Because the UK is quite established. You have the UK lesbian and gay immigration group.
yeah. And have you looked on Stonewall?
I think they have published a report about the detention facilities.
Right, so this is what you should
Right.
try and access. This is a free, basically, legal search engine for all cases in the UK. So if we go to, for example, it will have immigration decisions.
Okay. So even for the first decision, like the initial decisions will be online?
Yeah, so not all of them. So by first session you mean first instance?
Right.
hearing? Yeah. So not all of them will necessarily be on the list. But if you have you taken note of that?
Yes.
Okay, so the other...
The tricky thing about Hong Kong is we've never published that online. Like it's not public.
Right.
So we have to like go to every single asylum seekers and ask for that and ask for the permission.
Right, okay.
And that's why we sort of think that it's a black box and we don't know what's going on. And we can't really get hold of the scale. Okay.
Now this is appeals to the upper tribunal. So the structure is, I don't know if you're familiar with, there's a first tier, there's
Right.
the upper tribunal, you have high court decisions as well, which is where you're going to search on Bailey, and then you have the Court of Appeal, House of Lords. So Bailey will deal with House of Lords, will deal with High Court decisions and some tribunal decisions. But this will deal with upper tribunal decisions, which is what you want as opposed to the first tier tribunal, first instance cases, because it's the upper tribunal. When you appear in the first instance tribunal, you would refer to certain cases from the upper tribunal.
Right.
But another first instance decision will not carry any weight to your case, because the judge will just say, I'm not bound by that. Whereas if it's a country guidance case, it'll have CG in the background, in brackets. If it says it's a country guidance case, then that means that the first instance tribunal is required to follow the departure, but usually if they depart, then you'd be looking to do about what are they looking to do. Right. So, for example, if I just put so it'll come up with, it won't necessarily recognise the reference to LGBT, but if you put that in, there are cases. Now what that shows you is that these are unreported decisions. They don't carry the same weight as reported decisions. So you could go into a courtroom, for example, a tribunal first instance, and cite one of these, but a judge isn't required to follow that. So then you can look at reported, or if you want to look at a particular country, right, used as country guidance, which is more authoritative. Let's just see.
Do you think that's possible if we use one of these as a reference? For example, if you're appealing a case in Hong Kong, and then if the person is from the same country that's applying asylum in the UK, then that might be useful that we could quarrel.
Yeah, I think it's worth looking at the arguments. I have to say, I think in Hong Kong, like to be more receptive rather than to a tribunal decision, to a Court of Appeal decision,
Right.
or House of Lords decision, just because it's a higher authority.
Right. Would that ever go to a higher court?
It depends. Some of these cases
the
might.
XJ Iran case is in the Supreme Court.
So then, there's no way that you can find out unless you have access to a particular search engine.
Right.
So there's, for example, I don't know if you have this at the university, but there's Butterworth Selectors Mechanism, that's it. I don't know if that has a UK contingent or search engine, but that's how you do it. And if you generally want to have a look at these cases, then that's how you do it, certainly to kind of frame your arguments up. I mean, it's one way of doing it.
Right, okay.
It's quite useful.
Great. Thank you very much.
No, it's all right, you're welcome.
Do you have a card, or is there any way that I can contact you? Like
Yeah, sure. I'll give you mine. There you go.
Thank you. Thank you very much.
No problem.
Thanks. Sorry for eating your lunchtime.
No, don't worry about it. You've not had lunch either, have you? Half an hour for lunch is plenty of time. Right, what's the rush? Great. What food? What's on offer?
Not much, no. I've been happily apart from the logistics side of things.
I hope I haven't swiped somebody's notes. I think I have.
Yeah.
Dear.
Oh yeah, that's like rough scribbles.
So have you been working hard all week?
Actually, Lisa's been pulling away when it comes to
No, Lisa's been sending me emails nearly every day.
Yeah. But certainly our case hasn't stopped, so it's been a bit of a...
Have you got people in the office then? Have you got people in the office as well?
Yes, well not today, but yeah.
Yeah, that's the thing, isn't it?
If we had other events to these things.
I'm not sure if that was a good idea or not. What do you think?
I think it was.
It makes it more interesting.
It was more interesting, because at first we were so scattered across the room, we wouldn't be able to meet anyone in the eye and have a conversation. Yeah, I don't think it's a good idea.
Thank you very much. You're welcome. I was just observing how hard you've been working, because the first thing emailing me, you've been emailing everybody else just as well.
You're very kind, but thank you for coming and doing this. I mean, it's not like we haven't had a conference call or anything.
No, it's okay. Don't worry. It's great.
No, you've done really good coming over the materials and the information.
I just commented that I think most people for a long time. I know sometimes people yeah. But the way to kind of start with the colours and things, which Oh, is she? Okay.